We need to remember firstly what it is that we've learnt up until now in order to go forward. But I did warn you right at the beginning of this section that what's going to happen is the Gemorah is working with a premise of a Kal Vachomer. And last week we learned what that Kal Vachomer is. We're going to look at that again this week, at least from a different perspective. And what the Gemorah has to do is thoroughly, and when I say thoroughly, thoroughly test if this Kal Vachomer holds up to the robust logic that a Kal Vachomer needs to have. And the reason that robust logic is such a big expression over here is because there are 13 different methodologies that we could use to extract information out of verses in the Torah. Right? We say that every single morning. There are 13 different methods that we use in order to extrapolate information out of the Torah. The first of those is Kal Vachomer. And Kal Vachomer is pure logic, as opposed to some of the others that are actually a matter sometimes of tradition. That this is the tradition of how you interpret the verse. But Kal Vachomer is just brutal logic. That's why it's got to stand up to the very rigorous testing of logic. Okay, so what is the Kal Vachomer? What are we talking about? What are we trying to achieve? Where do we want to go with this? Let's try and remember what we're talking about. So we're living in a space that is called Hamoide B'Knas, Hamoide B'Miktsas Chayev Shvua. That's the world we're living in. Moide B'Miktsas means if somebody is willing to admit part of the financial claim against them, obviously they've got to pay the amount that they admit, but the halacha is that the balance, they're going to have to take a real oath. When I say a real oath, I mean one that is mandated by the Torah to ascertain that they really, really believe that they don't owe anything more than what they're acknowledging. Okay? So, moide b'miktsas hatayno yishoba. Somebody who acknowledges part of the claim against them has to take an oath. Fine. Good. Easy. Next case. So let's just look at the various scenarios so we can get to where we have to get to. Next case, next variation on the theme. So who are the guys we always use? Reuven comes over to Shimon, right? So Reuven comes over to Shimon. Reuven says, you owe me $1,000. Shimon says, I owe you nothing. Never happened. I don't know what you're talking about. What's the halacha? There are no witnesses. What's the halacha?
No, it's he said, she said.
No oath.
There's nothing.
The halacha is, exactly, he said, she said. The halacha is it's your word against their word. The guy owes you nothing. You're saying he owes you money. He's saying he doesn't owe you money. There's no reason why one person should have greater authenticity than the other. That's it. Finished. So, if a person outright denies everything that's being claimed from them, they get off scot-free. If they deny part of what's being claimed from them, obviously they've got to pay the part they acknowledge, and then they've got to take an oath. Next scenario. Reuven comes to Shimon, and he says, you owe me $1,000. Shimon says, no, I don't. Reuven says, well, here are Levi and Yehuda, and they are my witnesses that you owe me $1,000. What's the halacha now?
Pay up, boy.
Pay up, right? Can you pass on down, please? Pay up. Why do you pay up? Because witnesses are, what do they call it in today's world? Aiden, what do you call it today in today's world? Witnesses are the goat. Right? In other words, if you've got witnesses, that is the strongest form of an argument that you could possibly have. Because witnesses have the bearing of the Torah. If two witnesses attest to something, that's it. Case closed. There's nothing further to investigate. No further correspondence will be entered into. Two kosher witnesses, minimum. Okay? So the guy can scream till he's blue in the face, I owe nothing. Doesn't matter. There are witnesses. Zehu, that's what you got to pay. So what's the case we're interested in that we started to learn last week when we saw Rabbi Chia? Rabbi Chia says this. Reuven comes to Shimon. Reuven, who leaves Shimon alone already. Anyhow, Reuven comes to Shimon. And Reuven says to Shimon, you owe me $1,000. Shimon says, I owe you zilch, nothing. Reuven says, not so fast, Vanamerva. Right, you know that story, right? So he says, not so fast. Why? Because there's Yehuda, Levi and Yehuda are my witnesses. and they're going to prove that you owe me money. So Levi and Yehuda come along and they say, yes, you owe 500. So again, Reuven's claiming 1,000. Shimon is acknowledging 0. And these witnesses are testifying that Shimon owes 500. How much does Shimon have to pay right now? 500. What about the other 500? Comes along Rabbi Chia and he says, the other 500. Shimon has to take an oath that he does not owe that money. Says Rabbi Chia, why? Kal v'chomer. Kal v'chomer means I'm going to offer you a compelling, logical argument why you'd have to take an oath in that situation. What's the compelling argument? So Rabbi Chia used this expression. Sheloi tehei hoidoas piv. We don't want to have a situation where a person's confession is gedola mehadoas edim, is stronger than witnesses. We don't want to say that a person's confession is stronger than witnesses. Why not? Mi kal v'chomer. Because of a kal v'chomer. What's the kal v'chomer? That's what we need to test. Okay? That's what we need to test. And that brings us to where we are now, at this next piece of the Gemorah, where the fun begins. Now, the fun begins as follows. Before we can even look at this Gemorah, we need to appreciate the mechanism of the Kal V'chomer. The mechanism of the Kal V'chomer has to be so clear in our heads, because if you have any gray in the perception of what a Kal V'chomer is, each one of these tests and these arguments is going to just be difficult to understand each time. So we've got to be crystal clear on what a Kal V'chomer logic is. So let's remind ourselves. What's the translation of the word kal? Not kol. Kal.
Smaller. What?
Smaller, lighter, lesser, more lenient. Any of those things fits into the category of kal, weaker. So for the purpose of this conversation, kal, the weaker scenario. What's chomer? Stricter, stronger, more intense. Okay? So the purpose of this conversation, let's just say, the stronger argument. So I have the weaker argument and the stronger argument. Okay, so the logic of a Kal V'chomer says this. If the weaker argument can produce this result, definitely the stronger argument should be able to produce that result. Okay? So let's just do one or two examples that are less obvious than the guy who could do Hagbah. Let's just try and understand. So if we as a Jewish court of law are willing to accept your confession, and based on your confession, make you take an oath about what you did not confess. Got that again? If we as the Jewish court are willing to accept your confession, how many people are you? One. You're one person. And you're telling us that you owe 500 zuz. And yet on that basis, which is quite a weak proof to the fact that you might be owing more, just because of that whole psychological construct that we came up with last week, which is the guy wants to pay, but he can't afford to pay, but he doesn't have the chutzpah to deny, so therefore he's making a partial, right? So how strong is our belief that he actually owes more money than what he's acknowledging? It's not strong. We're just surmising there's that possibility. So it's a weak argument that he should have to take this oath. Why is it a weak argument he should have to take this oath? He says, I owe 500 rand. Why are you second guessing the man? Or let's put it differently, just to make this absolutely clear. Maybe the reason he's saying that he owes 500 rand is because he's a decent human. Maybe he knows that Reuven has no evidence. And he could have said, I owe you nothing. And then Reuven would have been checkmated. But he's a decent guy, and he doesn't want to do that. And he's saying, I owe 500 rand, because maybe he really believes that he owes 500 rand. Is that a strong reason to say, take an oath about the other 500? Is that a strong? It's not a strong argument. I can understand that there's a possibility. Okay? Now, what about this scenario? Reuven comes to Shimon, he says, you owe me $1,000. Shimon says, I owe you nothing. Stop, pause. Pause the video at that point. Does Shimon look like a bad person at this point? No. Not necessarily. Could be true. Okay, continue, press play again. Now the two witnesses, Levi and Yehuda, walk in and they say, Shimon, come on. We know, we've seen that you actually owe 500. Now what does Shimon look like? I don't think we can trust you, Shimon. You said you owe nothing, but there are witnesses who say you owe something. I don't know, your credibility does not look watertight right now. So now, is that a stronger reason to test his credibility? Is that a stronger reason to make him take an oath? Sounds like it. Because if in the so-called weaker case, which is the only reason I'm making him take an oath is because I'm not entirely sure what he was thinking when he denied part of the oath, and yet as part of the claim, and yet I'm making him take an oath, then for sure, if people seem to illustrate that he is not trustworthy because they're testifying against what he says, surely then we need to take this guy through the whole process and make him take an oath, right? That's the kal v'chomer. About the balance, because Ruvain said you owe me 1,000 and he's denying that he owes, right? Is this clear? Is it clear what the kal v'chomer is? Now I'll tell you why we have to test this. If you've ever watched any kind of a courtroom drama, whether that be real or for TV, the job of a lawyer is what? Yeah, that's what they say. The job of a lawyer is to enrich himself. Right, okay. What's the job of the lawyer? Yes, of course, he's got to represent his client. So what's
convince the judge?
Got to convince the judge of what?
His argument that his client's innocent. Or
No, he does not. The lawyer does not have to convince the judge that his client is innocent. That's not true. No, that's it. All he has to do is introduce reasonable doubt. That's the lawyer's job. The lawyer's job is not to prove my guy is innocent. It's to prove that you can't prove he's guilty. That's my job as the lawyer. Right? As long as I can introduce reasonable doubt into the courtroom, you can't prosecute. Right? So, do we know that this is a kal v'chomer beyond reasonable doubt? In other words, it suits us to say that the guy admitting to part of the claim is less compelling than witnesses proving part of the claim. It suits us. It suits us to say that, because then we could say the kal v'chomer, and then we could say that the witnesses are going to make him have to take an oath for the balance. But is that accurate? In other words, is it accurate that a person's admission is rarely a less compelling story than witness? Is that accurate? That's what we're going to keep testing. That's what we're going to keep testing. Now, straight away, I'm sure you could think, we're not there yet, but straight away, I'm sure you could think of a very compelling reason to flip that script and say, actually, I would think a confession is more compelling than witnesses. Okay? Straight away, you could think that. But we're going to look at a whole lot of different things. Mm-hmm.
I'll take a step back. The
Sure.
guy that denies everything, you saying that it's like a fairly weak case. It was the kal part of the kal.
No, the kal is the person who admits part of it. He admits...
But doesn't that give him credibility that he's admitted
Exactly.
part of it?
Exactly. So why should he have to take an oath? It's
Yeah.
kal. It's less reason to make him take an oath.
Less reason
Kal.
to make him take an
Kal.
oath, yeah.
Less reason to make him take an oath.
So the guy who admits some has got less reason to take the oath.
There's less reason to force him to take an oath because he seems like a decent guy.
Yes, and
Whereas the
what's
person who denies everything, and now witnesses come and say, what do you mean deny everything? We have evidence that you owe something. I don't think he's so credible. Therefore, chomer, there's more reason to have an oath. That's where we're coming from. That's why I said we've got to get this clear.
It's somewhat ironic that the dishonest guy is taking the oath. I know we were going back a few
Yes,
steps.
yes, that is true, and it will be part of the question, whether it's in this Gemorah or a different Gemorah, if you can accept an oath from somebody whose credibility has been destroyed by witnesses. Great question.
Just to finish the thought, but the guy says, I owe you nothing, he's off the hook. He doesn't even have to take an oath.
That's right. Why? Because nothing's destroyed his credibility. At that point, it's one person's word against another person's word.
But isn't it like a falsality to, like, just because somebody has a bad reputation now, you just don't trust them.
Okay, and that's a great question. So are we saying, that's a very good question, are we saying that because a person has evidence against him, we don't trust him, full stop? Are we saying that? We're not saying that. We're saying in this case, we can no longer trust your testimony in this case because it's been disproven. Your testimony was that you owe nothing. The witness's testimony is that you owe something. So in this case, we're not sure that we trust you. We're not writing you off as a criminal, which, by the way, is why we can trust you to take an oath.
So
Right?
there's an element
You're
of
nothing too
doubt.
hard, take off.
Well, not only because we haven't yet established that you're a criminal. If a person is established to be a perjurer, we're not going to allow them to take an oath. We haven't established that yet. We just have established that in this case, we can't trust you.
So the witnesses introduced doubt.
The witnesses introduced doubt to his credibility. Yeah. They introduced clarity about the fact that certain money is owed, where he said none is owed. So there's clarity about that, which in turn creates doubt about his integrity because, hey, if in fact you owe money, what is this business that you were saying you owe nothing?
So this the final.
No, that's fine. We've got to get this clear. This is very important.
Some of it is the lesser. What would be the more so? Like if you finish that sentence in colloquial, if he has to take an oath, then how much more so would?
Okay. So if the person who admits some of what is owed, in brackets, sounds like he's trying to be a mensch, and still he has to take an oath to clear his name on the balance, certainly how much more so the guy who didn't seem to be like he wanted to be a mensch because he denied the whole claim and now is proven to owe the money because there were witnesses, surely he needs the oath to clear his name.
Clear his name.
Yeah, because that's what we're worried about. What's that?
But there's witnesses.
There's witnesses to 50%. We need him to clear his name about the other 50%. Because remember, he denied 100%. So even after the witnesses come, he's still denying the other 50%. So we need him to clear his name about that now because the witnesses have raised big doubts about it. Okay?
Are we... You know, okay, let's say the pen gets damaged, it's 1,000 rand.
Right.
I'll loan you my pen and you damage it.
Right.
I say, geez, but it's damaged.
Right.
You owe me 1,000 rand.
Right.
You said, I owe you nothing. It's not that damaged.
Right.
In that scenario, you owe me nothing.
Okay, it's a little different because you've changed a fundamental part of the conversation. The conversation, as you presented it, is, I acknowledge that I used your pen.
Yes.
Okay, so if I acknowledge that I used your pen, that puts me into a different category to what we were talking about over here, which is a category of a borrower. And a borrower always carries liability for any damage unless it was completely out of the ordinary, what insurance would call an act of God.
Because I suppose what I'm getting at is if you genuinely feel that you don't owe the guy 1,000 and you genuinely, there must be a scenario. Not lies.
There definitely will be many scenarios like that, and the objective of law is to get past what you feel and establish what is clinically correct. Like looking at this with absolute objectivity, doesn't matter that you don't feel you owe the money. Do you? Don't you? Okay, so classic story: you open your car door and you hit the next door car, right? 99% of the population feels I don't owe the person anything for that. But the law wouldn't agree with you. Right? Running a red light because you live in Joburg, 100% of the population believes that that's okay. But the law doesn't agree with you.
But
So
according
sentiment-
to this, you saying he says I owe you nothing.
Yes.
He owes you nothing.
Yes.
So if you bang the guy's door,
No. Again, the scenario needs to have witnesses to know the scenario ever happened. So if you knock somebody's car door in a parking lot and nobody sees it, are you liable? Legally, you're not. Legally, you're not liable because you cannot prosecute. Should you have a conscience? Do you have a moral response? That's a different story. But legally, there is no legal recourse in that situation because there's no witness. There's no way to have a legal process. So we need to be able to distinguish between issues of conscience and issues of law. Law is black and white. Law does not consider sentiment. Law is not hung up on what you perceive the reality to be. Law is just, that's how it is. Okay? And that's why we use the expression that everybody is equal before the law. Equal means doesn't matter who you are, what your status is, or what your feelings are. Right? As they say, facts don't care about your feelings. That's exactly what law is meant to be. Okay.
Can I ask, with
Yeah, sure.
witnesses, is like a camera considered two witnesses?
Ooh, is a camera considered? Definitely not. A camera would never be considered two witnesses. And in the world of, now that we've reached the age of deep fake and AI, you understand why a camera can never be considered like two witnesses.
But even before, so like.
No, I'm just saying that the kind of the end proves the beginning kind of thing. But the Torah's principle is only witnesses constitute witnesses. You can use cameras for certain legal things halachically. For example, and this is not to decide an halachic opinion, but there is a school of thought that says, in terms of kashrus supervision, that cameras can play a role in kashrus supervision. But that's very different to evidence. The purpose of kashrus supervision is to be able to give the employee the impression that he's got to follow through on what the requirements are because somebody's watching, as opposed to evidence. Evidence needs to be watertight. You can't cross-examine a camera. So therefore you can't verify if the camera's been tampered with. Did somebody change the timestamp? Was it a person who was masquerading as so-and-so? You know, they wore the same kind of clothes. There are very, very strange things that can happen, which you can't test if you don't have a human to ask. So the Torah will never accept camera evidence. It was interesting.
I'm just not loving the you and I arguing. You feel 100% that I owe you, and I feel 100. Why don't we split it? I'm saying, like, why do I get?
Why do I get what?
I'm saying you strongly feel I owe you. I strongly feel I don't owe you the 1,000.
Okay, I'll settle this for you so easily. If you so strongly felt this way, why did you not document the fact that I owed you the money?
Would it make a difference?
Of course it was. Of course it would. If I come with an IOU that you've signed, hello, you owe me the money. If I come with a document that says so-and-so has borrowed X amount of money and it's due on such and such a date, and I can produce that, you owe the money.
But that can't be the reason why you don't pay. Because you both feel equally strong. So therefore...
I'm just saying the argument that says because you feel so strongly, you therefore are being, so to speak, fleeced of your money. I don't agree with that. If you feel that strongly, you'll protect your money. If that's your argument. I'm not saying that's our argument. I'm saying if that were the argument, then the counter argument is, well, be responsible. Right? Don't come crying because you left your laptop out in the rain kind of concept.
Relate with that, but I'm saying it's irrelevant if you're responsible or not in that scenario, in my view, because often you get, like, there's a relationship that develops. And you, like, all the documentation kind of
true.
evolves.
Yeah.
That is true.
And it
That
evolves.
that is
Also,
true.
So
the point
maybe we're
is-
playing a card game.
The
And I
point
say,
is
I
no one's
win.
got... No
I'm
one
gonna,
trumps
you got me
anybody
1,000
there.
rand.
Great. I accept both points, right? So the fact is that sometimes you reach a level of relationship. And by the way, people totally, radically underestimate how often goodwill is the cause of absolute fallout, right? So let's say that it's goodwill. So a person says, listen, just help me out. Yes, of course, you're my good friend. Here's the money. You'll pay me back when you can.
Often it's
Terrible
insulting to
strategy.
document it.
True. Well, is it?
No, I mean, because of the relationship. Like,
Because-
if I actually come to you and say, okay, you lend me $100, I say, okay, about, you know,
Fine.
you know, to be like what? Don't you try, you know?
No, I'm not disputing that. But the reality is, and again, this is why the law has to be totally objective. We get all of that. And sentiment is a big thing. And the road to where is paved with good intentions. Because at the end of the day, just because we have a good relationship and just because we trust each other does not safeguard us against things going awry. When things go awry, the law cannot support us on sentiment. The law can only support us on evidence. So I feel so strongly you owe me the money. That's great. Can you prove it? Because if you can't prove it, I can't have a legal process. You two can fight for the rest of your life. You could say, I don't believe it. We were such good friends. I've been so good to you. How could you do this to me? All valid. It just has no place in the courts.
you're just saying verbal is there's no play.
You take the risk.
Take the risk.
You take the risk. Hopefully it works. Hopefully that relationship is as strong as you believe it to be. Hopefully financial things don't derail the relationship. How often do they? I just heard a fascinating case today. Fascinating. With a person who wasn't ever in their life, never had money. And then the parent passed away and they're 4 siblings. And the parent divided the money in such a way that some siblings got cash and the one sibling got the contents of the house. Now when you hear that you think, never. Until they discovered that just the artwork sitting in that house was more than all the siblings combined. So what do you think happened? Now the siblings don't talk to that sibling. That was the outcome. So what money can do, and how it can absolutely sabotage and derail relationsves is
well, if it was
phenomenal.
worth less, he wouldn't have spoken to them. So
that's right. Exactly. Whichever way it goes, it's absolutely fascinating. It's absolutely fascinating, and. Look, I don't know why people think that rabbis are going to resolve these things for them, but the amount of times that people come to Rabbonim with their financial disputes, particularly family disputes, but often business disputes, it's off the charts. You think, my gosh, I always used to look up to you as a business person. I thought you really had your head screwed on. How on earth did you let this thing go like that? And yet it's commonplace. Commonplace. Right? And that's the problem. The law can't.
That's off camera.
but the fact is, the law can't do anything for you. Yeah. It's a tragedy. It's the kind of thing that you can't put the genie back in the box. But the law can't do anything for you if there isn't a legal framework, documentation, witnesses, or anything like that. And that's really the point here. Okay, let's come back to our Kal V'chomer. So we have now, and this is very important information, we have now chosen to focus on the Kal V'chomer from a specific angle. That's how we've approached this. In other words, what we've said is, look at this guy, such a sweetheart, such a mensch, owning up to a claim against him where there's no evidence. Kal. Less reason to make him take an oath. Look at that guy, lying through his teeth because there are witnesses who immediately testify that part of what he said is not true. Make him take an oath. Chomer, right? So the Gemorah is going to say, is that the only way to look at this? Because maybe what we should be saying is there's something intrinsic about confession that makes it chomer. Now, this particular case, yes, it sounds like this guy, but maybe there's something intrinsic to your own admission that can achieve something 2 witnesses cannot achieve. And if I could prove that there is another halakhic definition where you admitting something is more powerful than 2 witnesses coming, then I don't know if I have a Kal V'chomer anymore. Because a Kal V'chomer can't just be that I choose to cherry pick the part of the Kal V'chomer that works for me. I need to look at this objectively. Is confession really less of a deal than witnesses? So how are we going to test this? We're going to throw out a few scenarios, one at a time. So what about this scenario? Because in this scenario, I see that the individual can obligate themselves where the witnesses can't. And then we're going to say, okay, what's that?
We're at the table, right?
Now we're at the table. And essentially what we're going to do is, each time we're going to present this, and that's how we test the Kal V'chomer. Because if I can give a satisfactory answer, then that's no longer an issue. The Kal V'chomer still stands. Hey, well, what about this scenario? Because in this scenario, the individual seems stronger than the witnesses, and we'll test that. And if that could stand the test, then the Kal V'chomer is still in play. And that's what we're going to do now for the next 5 or 6 examples. Okay? Each of which needs background. So let's have a look at the backgrounds. Page 37. As we always do, we're going to start first with a bit of vocab.
Pencil.
So the first thing we're going to do is start with a bit of vocab. The first word on the list we've had before. Yud Daled Hey. Nothing to do with a hand, in case you're thinking Yad. It's nothing to do with that, right? Yud Daled Hey. Yes, no, yes. We've had it a few times, but in different formats. So it is the root of the word to acknowledge, like modeh, todah, hoi do'as ba'al din, which is what we're about to learn. Hoi do'as ba'al din. That's what we're about to learn. Okay? So that brings us to the next word, ba'al din. But before we do that, do you remember the term we had last week, which is called ba'al choiv? Do you remember that word, that term? We had it last week. Ba'al choiv. It's fine. Let's put it together. Let's reconstruct it. What does the word Baal mean? Master of, or? Right, so correct. So owner of. There we go. Baal, owner of. What's a choiv? A debt. Who is the owner of a debt? The creditor. I own the money that you need to pay me. Baal choiv. Great. Okay. So now here we've got Baal din. That is the owner of the din.
Din is law.
Din, law. The owner of the law. What do you think? Who do you think is the owner of the law? It's a funny way to say it. Do you think it's the judge, right? It's not the judge. It's a funny way to say it, but the minute we explain it, it's going to, oh, that makes sense.
The person who's laying the charge.
The
appellant, the person
the defendant. Baal din, he's the one who has the onus of going through the legal system to protect himself or to defend himself, right? So the Baal din is the defendant. Okay? And so actually in a financial case, it's the Baal choiv versus the Baal din. The Baal choiv is the person who owns the debt, and he's now trying to claim from the Baal din, who's the person who now has the court case against him. He's the one who is now being brought to the law. Okay, the next bit that you should know, Maya? 100. Good. And the next word, this is one of those dad jokes in the Gemorah class, dummy. So in this case, it's just the word dummy, but in certain places in the Gemorah, it says heichi dummy. So heichi means how. So the dad joke is, how's the dummy? That's usually what. So what's dummy? Dummy in Hebrew would be domeh. Domeh. Ever heard that word? Mi yidmeh lach. Yeah, right, exactly. Umi doimeh lach. What does it mean? Who is compared to you? So dummy means considered like or similar to, anything like that. Dummy. And that's why you could sometimes have the question, heichi dummy. How is this case? What's it similar to? What are the parameters, etc. So dummy means considered like or similar to. Okay, that's the vocab. That's the easier part of this. But the next part is you got to get this little technique because it's going to pop up again and again and again in each of these segments. It goes like this: Uma X she Y Einoidin she da 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 da. Okay, very difficult to imagine that in the abstract. So let's first do the translations. Uma and what? Okay, Uma. Now, what we really mean to say over here is, and what about? Okay, Uma, and what about? Then we'll say the case we're referring to. So, Uma, what about this case? So, what about the case of the guy who admits that he owes money? For example, share. What does share mean? That. And after the share, we'll say what the law is in that case, right? So, Uma, what about case X? Share, where the halacha is such and such. Einoi din, is it not logical? Share, that in the Chamur case, that should be the law. So in other words, this is the language that the Gemorah will use when it wants to fully unpack a Kal Vachomer. Right? What about this case that can have that effect? Certainly, the more chomer, the stronger, the more severe case should certainly have that effect. Okay. So that's the mechanism we're going to use over here right now. And then the last bit of introductory information that we have to know is an expression, a useful expression, because it does pop up in many places in the Gemorah, and that is hoidoas ba'al din. So let's put this together. Hoidoa comes from that word yudalid hey, which is acknowledgement, right? So hoidoas, the acknowledgement ba'al din of the defendant, kemeya edim, like 100 witnesses. Dami is compared. In other words, confession equals 100 witnesses. Can you see where the Gemara is going with this? You're telling me about 2 witnesses? That's nothing. Okay, so that's where we're going. Okay, so what's the Gemara going to do first of all? First, the Gemara is going to ask a shaila. Remember that a shaila is a question that is looking for information. This is not antagonistic. It's not challenging us. The Gemara just simply wants to understand what you meant when you said. So you, Rabbi Chia, said that there is a kal v'chomer, and that is the logical basis for our belief that if there are 2 witnesses to part of the claim, the guy has to take an oath about the balance. So let's understand the kal v'chomer. Umay kal v'chomer. And what is the logical construct of this kal v'chomer? Right? Umay kal v'chomer. What is the kal v'chomer? Now, anybody who's learned a little bit of Gemorah has no choice but to bite their tongue when they read the logic of this kal v'chomer, because if you know a little bit of Gemorah, you're going to say, but I don't understand even what you're saying. So if that happens to you, if you say this is completely illogical, just bite your tongue. Hold that thought, because the Gemorah knows that you're going to do that, and the Gemorah will deal with it. Okay, so what's the kal v'chomer? We need to unpack the full logical structure of this kal v'chomer. Uma piv. Okay, let's try and translate this. Uma, and what about? Because remember, we're building this construction, right? Uma, and what about piv? What's piv? What's a peh?
Mouth.
A mouth. So piv, his mouth. Wait, before you write anything, what do you think we mean when we say his mouth? His confession. His confession. Uma piv. And what about his confession? She'ein mechayvoi mamoin. What's she'ein? That ain't. Right? That doesn't. She'ein, that doesn't. Mechayvoi. That doesn't. Mechayvoi. What's the word chayav? Obligated, right? Mechayvoi, obligate him. She'ein mechayvoi mammon. No, mapi. What about his confession? She'ein mechayvoi. That does not obligate him. Mammon. What's mammon? Money. So what about his confession? That does not obligate him to pay money, and yet mechayvoi shvua does obligate him to take an oath. Okay, so what do you think that the Gemara is saying over here that doesn't obligate him to pay money? What does it mean? His partial confession does not obligate him to pay the balance of the money, but does obligate him to take an oath about the balance of the money. You see how this works? Right? He confessed. Surely that shows us that there is something to what the claimant is saying, and yet it's his confession does not obligate him to pay money beyond what he acknowledged, and yet it does obligate him to take an oath beyond what he acknowledged. So here comes the kal v'chomer. Eidim. Correct. Shemechayvin oisei mamoin. What shem mechayev mean, or what does mechayev mean? Chayev is obligated, right? So shem mechayvin, that they obligate him. Oisoi, him. Shem mechayvin oisoi, they obligate him mamoin, to pay money. What does that mean? There's an amount of money that he says he does not owe, right? and the witnesses can make him have to pay the money he says he does not owe. Let's compare that to his confession. When he makes a confession, does he have to pay the money he says he does not owe? No. Does he have to take an oath about that money that he says he does not owe? Yes. So now let's have a look at these witnesses. Can these witnesses obligate him to pay money he says he does not owe? Yes, they can. Who's stronger now? Because his confession didn't make him have to pay money he doesn't acknowledge. Their testimony does make him have to pay money he doesn't acknowledge. Who's stronger? They. And if he, the weaker, the kal, through his admission, has to take an oath about the money he says he does not owe, Einoi din, is it not then logical that they, witnesses, should obligate him to have to take an oath on the balance? You see how the logic works here? If I say I don't owe you more than half, I don't have to, based on that testimony, pay you more than half. But I do have to take an oath. If those witnesses come along and say you owe half and you're saying you owe nothing, not only do they make you pay the money, because look at that, they're making you pay. I want to say they should make you take an oath as well on the balance, because they're stronger than you. They got money out of you that you didn't acknowledge.
So you don't have to take an oath on the balance.
No. Again. Okay. So let's do it like this. There are two areas we have to examine: money that the guy acknowledges, money that the guy denies. Okay, those are the two areas. Then there are two possibilities of how we get information about these two areas. Either he owns up, or witnesses appear. Okay? Then there are two possible outcomes. Either he pays, or he takes an oath. Okay, those are the scenarios we're working with. Right. Scenario number one. He admits that he owes 500 out of the 1,000. Okay? What's the law? The part that he admits, we're not interested in that. That's not where we're debating over here. What's the law about the part that he denies? Does he pay any of it? No. Does he have to take an oath for it? Yes. So his testimony against himself, because that's what a confession really is. It's a testimony against his personal interest, because he'd rather keep the money. So his testimony does not make him pay money he denies, even though there's a claim against him on that money. But his testimony does force him to take an oath about the money he denies. Right? Okay. Now let's look at the witnesses. In the case of the witnesses, do the witnesses make him pay money that he denies owing? Yes, they do. What about the balance that they did not testify about, but there's still a claim against him? Don't you think the witnesses should be powerful enough to make him take an oath? Why? Because they're powerful enough to make him pay something he doesn't admit to having to pay. Then they surely should be powerful enough to make him take an oath about something that he claims he doesn't have to pay. Because even he could do that to himself. That's the kal v'chomer. It's just that in the witness's case, it's two segments of what he's denying. One segment of what he's denying, he's going to have to pay because there are witnesses. The other segment of what he's denying, well, now we're saying, we think you should take an oath about it.
But what's the point? Because he denies it totally anyway.
Well,
because the witnesses have to tell them to pay.
That's right.
So he's just denying.
That's right. So what's the point? Good question. You're asking, is there utility in this exercise? That doesn't matter right now. We're doing the theoretical understanding of what the power is of witnesses. Does it have utility? We don't know yet. But in order to do an assessment of how this whole system works, we need to be able to ask the question in concept. That's where we are. No, that's not really the bite your tongue moment. Bite your tongue moment is coming now. What were you going to say?
I was going to say, what happens if you take an oath before the witnesses come, and then they come, and then they say, oh, you owe 500, do you still have to take another oath after?
Generally not. Generally, you don't repeat an oath on the same claim. Generally not. It's a good question. So should we leave on a cliffhanger? Let's leave on a cliffhanger. Asks the Gemorah. Now we're talking about a kashya. What's a kashya? A kashya is not a curious question. A kashya is a challenge. I don't accept what you just said. You just said that confession does not make a guy pay money. Maybe in that case. But as a principle? Upiv ein mechayvoi mamoin question mark exclamation mark. Does a person's confession not obligate the person to pay money? What are you talking about? Veha. We've had that word before. Veha. Highlighted over here in red because it is the word that illustrates that this is a kashya. Veha. But. What's but? We have a principle. Then when a person confesses, it's as good as 100 witnesses. If 100 witnesses say that he owes money, is he not going to pay? I don't get this. You're telling me that the issue is that his confession's not going to make him pay money. There are so many, maybe not in this case, you're right. In this particular case, it's not. Do you know how many other cases there are where a person's admission makes them have to pay money? Your kal v'chomer makes no sense. The whole principle of your kal v'chomer is witnesses can get money where confessions can't. But confessions can. So where's the kal v'chomer? That's our big cliffhanger kashya for next week. Because what the Gemorah is going to do, the dance the Gemorah is going to do right now to say, well, when I said money, I didn't really mean money, is going to be very interesting.